City of Hawthorne to withdraw its membership in the Los Angeles Regional Interoperable Communications System, LA-RICS, Joint Powers Agreement, JPA. Item number seven, resolution number 7738. A resolution of the City Council of the City of Hawthorne, California, authorizing the city manager to execute any and all documents necessary to cancel an existing residual receipts note and accept a new surplus cash note for the benefit of a 75-unit Teleq senior housing project. Item number 7, resolution number 7742, a resolution of the City Council of the City of Hawthorne, California, designated 122nd Street between Menlo Avenue and Freeman Avenue as a preferential parking zone. Item number 8, resolution number 7743, a resolution of the City Council of the City of Hawthorne, California, authorizing the examination of prepaid mobile telephone services surcharge and local charge records. Item number 9, resolution number 7744, a resolution of the City Council of the City of Hawthorne, California, authorizing the city manager and the city attorney to execute certain documents required by the Board of Equalization to collect the city's utility user tax on prepaid wireless service for adoption.
I'd like to pull number 8.
I'd like to pull number 6.
Discussion number 5.
I'd like to pull number 9.
Okay, let's
I'd
start.
like to pull number 9.
Let's vote on the rest. I move.
Second.
Please vote.
Vote reflects mayor and city council voting yes.
Item number 5. Please go ahead.
To the chair.
Yes.
Thank you. With regards to the resolution 773 and to withdraw, I'd like to ultimately bring back the February 24th, 2009 to current, the expenditures that the city made in that time to the agency and report back. I also want to know if there's any equipment that we currently have that was purchased with regards to this program. And we could bring that back at a later time, but I want to ultimately know what the monies were and were not spent on this program.
Go ahead, Chief.
No, that's fine. Bring it back. Thank you. That's it?
Okay.
You guys have 8 and 9?
Number 6 first. Who pulled 6?
I pulled number 6. I
Yes,
just
sir.
wanted, we asked the city manager to look in a few items, if you can explain the matter to us, the Teleq matter.
Are you talking about the questions that were asked at the prior council meeting?
Right.
Through the chair.
Yes.
Mr. Michelin, so, I'd like to concur with that request, only so that we can, just the public can hear the responses that we heard to explain. And maybe there might be some misconceptions, maybe there might be some truth, so,
Exactly.
okay?
To recap, this item has to do with Teleq. It's a senior housing project, 75 units located on the corner of 130th and Doty. It was built approximately 1987, and it houses low-income seniors. The question was asked, who monitors whether or not they are in fact low-income seniors? And the answer is HUD. The second question was, did anybody call Building and Safety to inspect the property? And the short answer, I have to go through the history. As I said, the project was built in 1987. In approximately 2003, a resident of the structure indicated that the floor appeared to be buckling. It was inspected by the building owner's engineer, and it was determined not to be a significant problem to the safety of the building. They did, in fact, inspect all the floors and determined that they needed to repair the trusses on the first, second, third, and fourth floor. They initially applied for a grant through HUD in 2005. but they realized that the grant that they were applying for wasn't going to be enough to pay for the repairs, so they returned the grant funds. And mind you, because the amount of the repair was so expensive, but in light of the engineer's report that it did not pose a safety risk to the tenants, they held off on doing these repairs until the year 2013, when interest rates went down, and through HUD, they were able to structure a proposed loan through a third-party lender to make this work. The third-party lender is willing to give them, I believe, 1.6 million, and on top of that, they're able to put $800,000 into a fund for future repairs. The building department never inspected the property. Instead, the engineer, the architect, and the building owner brought plans to the building department. Those plans are still in plan check. Hopefully they'll be finalized soon. Another question was asked, who is the one that determined the cost? The building department did not determine those costs. The costs were determined by the building owner's contractor. I believe Councilmember Vargas also asked, how does HUD determine whether or not the tenants are in fact low income? Again, the average tenant pays between $225 and $275 a month. HUD subsidizes the remainder of the rent. HUD uses a contractor to actually audit to make sure that the tenants of the building are low income as determined by HUD guidelines. Another question was asked, do veterans live in this facility? There are 3. Right now, it's not a veterans housing project, but low income seniors include veterans. I may have answered this. Who is the lead agency on the project? It is HUD. Will the refinance have an impact on the amount of the rent? The answer is no. The rent will remain the same. The majority of the funds are being refinanced through a third-party lender. The small amount that involves city funds is actually not even city funds. It's just HUD funds in the amount of $80,000 based upon a note that was approved by the city back in 1987. And what the Teleq is asking the city to do is to cancel the $80,000 note and to replace it with an equal note of $80,000. And that's what we're doing. In exchange, they're extending the affordability covenants attached to this project by 20 years. I hope that answers everybody's questions.
Is this going to have any effect on future HUD funds to the city or HUD funds to the city right now?
No,
Is this going to have any kind of effect on the city budget?
no. This is restricted funds for low-income housing. So when the money is repaid back, this does not go into the general fund.
Okay.
To the chair.
Yes.
Let me just make mention that I did meet with the city attorney's office to get a better understanding of all the questions that was asked between Councilmember Vargas and myself, and just going over what you made mention with regards to, my concerns were the rent being altered because of the new note. So I just want to rest assured that residents are not going to be hit with an increase because of their building being reconstructed or fixed in a sense. So I'm satisfied with that, and I'm willing to move forward.
Through the chair?
Yes.
Okay, I guess what I wanted to just kind of note, because there were some questions from our residents, and we're accountable to you. You've been hearing the word teleco is like a 6-letter word, but it sounds like a shorter word. And the reality is that there's seniors that are living here at this location, seniors, and there's a problem with their housing, where the roof over their head, or basically the floors over their head. So there's some urgency in repairing that and trying to improve their quality of life. So these are seniors. We're promoting senior housing as an alternative to the high-density housing that might be proposed. So we're asking for senior housing, for future senior housing. And how could we ask for future senior housing if we can't take care of the existing senior housing that we have now? So HUD is involved. There's a lot of accountability. There's a lot of hoops to go through to be able to qualify. HUD, is very strict, and they have a lot of oversight over this property. I feel satisfied that, if anybody's going to police this, it would be HUD. But to those people who are asking about Telecu's involved, Telecu, we have to separate the situation over there in Centinela that's going on with their support of candidates and whatever meddling's going on over there with this project that we have here. Not all the projects that Telecu does are questionable, and there's probably bad dealings, political dealings, etc. They own this property. They've owned it for a while, right, Mr. Mihara?
1987.
1987. That's about whatever, like 20 something years, 28 years or something like that. So there's a problem. There's some good oversight. We're not rewarding Telecu. So for those people that might think that, we're not rewarding. The money's going to go into repairs for seniors that are living there, and there's going to be oversight to cover this. So I just wanted to clarify that because I think there's urgency in this matter, and I think we should go forward.
I move.
Second.
Please vote.
Just clarification, Mr. Mayor. We're voting on 5 and 6, or only 6?
I believe they just voted on 5, and
Oh, we
now they're
have it.
voting on 6.
Yes, they did not
We
take
did
a
not
vote
vote
on
on
5 yet. We did not take a vote on 5.
Okay,
So
let's
can
make
we-
a motion.
Can we
Let's make
separate, can
let's
we
make a mo-
separate the 5 and the
Excuse
6?
me, let me finish. Let's make a motion to move on 5. Do I got a second?
I second. 5
I
and
just
6.
made a second. He made a motion on 6. Let's vote. So that's
Okay.
both on 2.
Okay, we're voting on both.
2. 5 and 6.
Okay, just clarification. Thank you. Vote reflects mayor and city council voting yes.
Item number 8, I understand you guys are trying to tax prepaid phones. Is that correct?
Yes.
Okay.
Right now, a tax is collected on all wireless, but all cities and all counties in California aren't able to collect on prepaid phone cards that are sold at retail places like Target and Best Buy. And in order to capture that, the state passed AB 1717, which now allows the tax to be added to those prepaid cards over at Target and Best Buy. And the way that it's going to be done is through the State Board of Equalization. And the resolutions number 8 and 9 are connected.
Right.
It allows the city manager and the city attorney to sign the required documents necessary to start this process, and also assigns the task to the finance department to review all the records in order to make sure that the taxes are being collected appropriately.
I have one issue with this tax with prepaid individuals that have prepaid phones. Number one, State of California, California Public Utilities Commission created a program called the Lifeline Program, which gives out 27, probably here just in the city of Hawthorne, 27,000 individuals from seniors to low income to veterans are eligible for free prepaid phones. It gives you unlimited minutes, unlimited text messaging for $22 a month, but which is subsidized back from the state of California. I want to make sure those individuals are not taxed. So it's 27,000 people just in our city that qualify for this program that, probably a lot of people don't know about. But that's a lot of individuals. I want to make sure they're not receiving a subsidy or bill, or even though it's 10, 11, 12 bucks, that even though the state of California is giving you the subsidy, that these individuals, because when they give them their social security number, all their information, they're getting a voucher that allows them to have this prepaid phone. I want to make sure that these individuals aren't receiving tax. The only person that's going to be able to tell you that is California Public Utilities Commission, which I need a letter from, and also our Board of Equalization President Jerome Ward. So can we get letters from those? If those two say, those 27,000 people here in the city of Hawthorne aren't being taxed, I'm okay with it. Other than that, there's still, I'm sure my colleagues have a lot of things to say regarding people being taxed on prepaid phones. You're getting unlimited for $35. The reason why you're on, $35 prepaid, you don't want to be taxed additional $7, $8. You might as well go to postpaid.
To the chair.
Yes.
And I have some other concerns as well. I know that there was made mention of reviewing records and going back.
Yeah.
We already have concerns with our collection agency taking to the extreme with 10 years back in the rears. When you speak on reviewing records and going far back, I mean, is this free leverage for however many years? And I understand it's revenue to the city, but let's be fair here. This is something that obviously isn't new. It is AB 1717. That's probably last year accepted, last year drafted, last year passed,
Probably,
last
yes.
year roughly. That's one of my concerns. I want a better understanding of what we're talking about when we're talking in the rears or reviewing records and ultimately charging our customers. I want a better, I don't think we have a sense of exactly in numbers how this is going to help. I mean, I understand it's revenues, I get that. But how are we helping our customers, our constituents?
The reason why we're helping all of the citizens in the city is that the taxes are collected on not a consistent basis, because the people that are billed by Verizon or these other companies, they're being assessed a utility users tax. The people that are buying a prepaid phone card are not, and this equalizes the tax on everybody. And the reason it's being brought to you today is the State Board of Equalization needs the resolutions by September 1st. We do have time. We can bring it back for the next meeting. I don't know how to answer the mayor's questions
We have 2
on
weeks.
how we determine who's qualified when they buy a prepaid phone card, because we do have some procedures in the city where people come in to the city treasurer's office to apply for certain senior discounts. But how you do that when you buy a prepaid phone card, I don't know what kind of mechanism or procedure we can adopt to accommodate that.
Can I just add, and I'm comfortable with tabling this item, and I'd like to get the support of the council as well, because there's a lot of unanswered questions here. I understand there's a request for a letter from, our Board of Equalization. That's a given. I'm sure he's going to be sending something anyhow, because it's his policy. However, I think we owe it to the residents and to ourselves to understand fully what we're asking with regards to review of records. Who's going to make those review of records? Is it the Board of Equalization? Is it our department? Is it staff time? There's a lot of unanswered questions, and I don't want to continue to have you answer everything. Maybe it's best if we just provide us either a legal confidential or provide us some sort of a report with all the questions that have been asked here tonight.
Oh, that's fine.
And bring that back?
I'll bring it back.
Okay.
Okay?
Thank you.
Through the chair?
Yes, sir.
Yeah, I guess the group who would be reviewing this for Councilwoman English's towards her question was, our UUT revenue consultants will examine the local charge records. So we have consultants that are out there. But with regards to the vouchers that are given, ultimately the question I want to have is it a voucher that says, with this voucher, you are entitled to a phone service with the phone, for this amount of time, for a month's worth of time? Or is it a specific, does the voucher come with a certain quantity? Because if it's a voucher that allows for somebody to use a phone unlimited use for the whole month or something, then I guess the whole argument against this tax would be, hey, we don't want the individuals to put money out of their pocket apart from that voucher to be able to pay a tax. Okay, so it should, but if it's a specific amount on that voucher, then the story changes, you know? They get to pay for a certain service, and they might have a little bit money left over on that voucher, and maybe this tax could be considered, but I kind of share their concerns on this. If you could find out how that voucher system works, please, because it could be either case, and then change the story here.
Okay, we'll bring back
you.
number 8 and 9.
Yes. Item number 10.
Now is the time and place for the continued public hearing on Prime Minister Development Incorporated appeal of the City Hawthorne's denial of building and grading permits, Farmers Boys Restaurant. Proposed location, 2750 West 120th Street on lot number 2 of tract number 53336-02. The lot is currently occupied by a parking lot on the lot's northern portion and a retail use building on the southern portion. Declaration publication filed. No written communications were received.
Is there anyone who would like to address?
Oh, no, before you start, let me read my recusal.
Thank you.
I will be recusing myself from item number 10, the public hearing regarding Prime Store on the agenda tonight. As the city attorney, I have been providing legal opinions to the city council regarding Prime Store's position as it pertains to the issuance of the building and the grading permits. Under the holdings in Nightlife Partners versus City of Beverly Hills and Quintero versus City of Santa Ana, it is not advisable for a city attorney to perform dual functions of both advocate and advisor to the city council. Therefore, I will recuse myself from the Prime Store appeal hearing. Mr. Cotty from the law firm of Jenkins and Hoagland will be replacing me for the entirety of this public hearing.
If you guys don't mind, let's keep our comments to 5 minutes. We have this much information on both sides already. So both sides, just keep it 5 minutes, please.
All right, thank you very much,
Yes.
Mr. Mayor. I will do my best. My name is Kevin Ennis, Special Counsel to the city staff on this item. Why are we here tonight? We mentioned at our last public hearing, which was on April 14th, that the building official determined that Farmer Boys Restaurant needed a lot split. Prime Store has appealed the building official's decision, saying they don't want to have a lot split application process by the city. If no lot split approval is required, the Prime Store will be able to receive a building and grading permit without review by the Planning Commission. This is information on this slide about the site, former Northrop Grumman site located south of the 105 freeway. Here's a vicinity map that shows the location of the lot. It's kind of in the center. It's a north-south lot just south of 120th Street. This blue trapezoidal image is what's referred to as the runway protection zone. To the far left is the Hawthorne Municipal Airport. The location of the proposed restaurant is shown in about the center, in the center of the flight path. What is now on the Prime Store lot? As you know, there's a building on the southern side of their lot, which includes 3 tenant spaces, Ross Dress for Less, PetSmart, and a currently vacant unit. They're requesting to add a restaurant in the northern portion of their property. Here's another image of their project. The southern green is what's already there. That is a 3-tenant building. They're proposing to add the red restaurant. As further background, when this area was redeveloped back in 2001 as part of the Exchange Project, there were mitigation measures imposed to preclude development of this portion of the property. And specifically, it said no restaurant or other similar use of that density shall be located in the runway protection zone. That mitigation measure is no longer enforceable today, but is guidance to you. Here's the chronology of this particular application, beginning in August 27th of 2014. They, in fact, did submit a lot split application. In March, they withdrew it. Why is a lot split required? We have detailed information to you in the staff report and in this presentation, which I will speed through, but basically, if they want to lease the property for the development of a new freestanding building to be leased to somebody else, they need a lot split unless, and there's an exception which we'll explain in a minute, the project is not subject to some other local zoning or building review procedure. Here's what they did apply for back in August and they withdrew in March. So here's the exemption. If the project is not subject to review under other local ordinances regulating design and improvement, if it's not subject to review, then it is subject to the lot split procedure. We've concluded that this project under your zoning code is not subject to review for a CUP or design review, and therefore it is subject to the MAP Act. It doesn't fall into this exemption. We have talked exhaustively in the prior hearing and in the reports as to why the exception is not satisfied. And again, it's because this particular development isn't already subject to some review process under your own local zoning and ordinance regulating design and review, design and improvement. Their principal assertion, meaning the applicants, that merely reviewing the project under the building code is sufficient to meet that exception. And as being a local ordinance regulating design and improvement. We believe this is factually and legally inaccurate for 5 reasons. First, their position is contrary to the legislative history. And looking at that legislative history, it's clear that the legislature indicated that they would give cities the discretion to either have a local ordinance through their zoning process to regulate design and improvement or under the MAP Act. Mere compliance with the state building code is not consistent with this legislative history. Second, we believe that Primestor has misconstrued the building code and its impact. It's not a local ordinance regulating design of subdivisions. The city's building department did not draft the contents of that code. Ray Shun is not your planner. Greg McLean is. Ray Shun is your building official. Ray Shun does not review projects for design and compliance with the city's general plan. He is therefore not, Ray Shun, the person that would review this for design and improvement. 3, Primestor's position deviates in how the terms are defined and interpreted in the MAP Act. We have an expert opinion that we've brought before you by a gentleman named Alan Seltzer, who has written a letter that's in your materials that gives a good background on why the MAP Act definitions and how that's been interpreted by the courts over the years does not interpret a building code as being a kind of local ordinance regulating design and improvement. Number 4, Primestor's interpretation is contrary to the purpose of the MAP Act. The MAP Act, not the building code, is the primary regulatory control for design and improvement. Absent that review process, the city would have no opportunity to control how a lot is configured. And lastly, number 5, as I indicated, Primestor's argument defies preeminent expert opinion. We've sought and obtained that expert opinion. He's provided it to you, and it is before you. He has concluded that in a very compelling opinion, that the city's decision to deny the building and grading permit until a lot split application is processed and approved was a correct determination. This is important because if you accept Primestor's position that this is exempt from your lot split approval process, it will not go before the Planning Commission. You will lose control over the regulation of the shape, size, location, configuration of this particular lot. It'll mean automatic approval of additional buildings within commercial lots that meet basic building standards. This could happen to other properties in that vicinity. How many more buildings could be ministerially approved on the Primestor lot with no Planning Commission review? You see the red spot at the top, that's their proposal. There could be others approved as well. Here's an example of what could happen on other sites in the RPZ under this interpretation. You could have each one of those red dots be a separate building leased to fast food developers or others with ministerial review. The applicant makes a significant case about past applications. Over the past 30 years, there may have been a situation where the city has approved the construction of a new building to be leased separately on an existing lot without a lot split. They point to the Burger King on Jerry Jamgochian Shopping Center as one of those examples. In contrast, your record does show back in 1989, this city did in fact approve a lot split for the lease of a commercial building on a lot. So you do have a record of doing exactly what we suggest the MAP Act requires here in Hawthorne. We suggest you follow what was done in 1989 with the Carl's Jr. restaurant situation, not what was done in Burger King on Jerry Jamgochian's property. Your goals, of course, are to promote economic development, support new restaurants, and staff also wants to accomplish those goals, but also preserve your Planning Commission's proper authority to review the appropriate location of buildings and future lots so as to not create a safety hazard. This Planning Commission, if you allow this to move forward into their procedures and through the lot split, would be looking at safety of restaurants and patrons in this area, safety of aviators, appropriateness of this site as a restaurant. Look into what the FAA has determined and not determined. Lastly, two things, abrogation easement. We looked more closely at that document and have found language in it that precludes development on this site. Although a typical abrogation easement would only deal with encroachments into flight paths, this has a more strict ground-borne component in this easement. And we provide text and language as to why that is the case. And we've shown an exhibit where this portion of the lot would be subjected to that. The FAA has not approved restaurants at this current location because they recommend it not be approved. They've recommended that, and to be clear, let's just quote them, structures which will result in the congregation of people within the RPZ are strongly discouraged in the interest of protecting people and property on the ground. Your airport is operated pursuant to grant assurances. Those grant assurances require that you take all reasonable steps to preclude the development of projects in this area that are inconsistent with the airport operations. A way to vet all of these questions is if you go through the lot split application process and have this project reviewed pursuant to CEQA. Your options tonight are to uphold the building official's denial of building and grading permits until a lot split is approved by the Planning Commission. Alternatively, you can grant Primestore's appeal and allow the building and grading permit to be issued for the restaurant without a lot split approval and without review by the Planning Commission. Whichever decision you take tonight, we recommend that you direct staff to prepare a resolution to be brought back to you, memorializing your findings and rationale for your decision. And with that, I'll conclude and thank you. And if you have any questions, be happy to answer them.
I don't have any questions.
Thank you.
Yep.
Good evening, Mr. Mayor, council members. It's a pleasure to be here before with you tonight. I thank you in advance for your patience and your thoughtful consideration of our case. I'm going to take 1 second. I just put out that Mr. Ennis took 10 minutes, and I hope that I can have at least that much time, but it should be pretty straightforward here. I'll try to keep it at 5 minutes. We submitted a number of documentations, and I also have hard copies of our PowerPoint if you'd like those. Is it okay to let me submit those? Might be easier to look at the hard copies rather than the screen there.
Thank you.
Again, my name is Alfred Fryho. I'm a partner at Shepard Mullen. I represent Primestore, the developer and owner of the property that's located at 120th Street and Wilkie Avenue. It is comprised rectangular site, as was mentioned. It has a PetSmart and a Ross Dress for Less. It's about 3,200 square feet, The proposed development is a restaurant of approximately 3,200 square feet. I want to point, as we made previously, is that the restaurant, as proposed on the site, is by right. What that means is that the restaurant is consistent with the general plan and consistent with all the zoning requirements that have been placed on the property as a commercially zoned property. The issue before you today, notwithstanding a number of other allegations that were made in correspondence that we received on Friday, in excess of about 100 pages, is very simple. And that is whether our project is exempt from having to apply for a lot split to build the commercial building. And by way of reference, the reason why we initially applied for a lot split was the fact that we wanted to sell that portion of the property. That's the reason why you need a lot split. We have no intention of selling it. We have every intention of continuing to own the entire property and continue to operate it as a unified development. The exemption under the MAP Act that applies in this case is when you have a situation when you're leasing a commercial center, the MAP Act, without this exemption, would apply. The exemption says that you qualify for the exemption so long as the city has the ability to review the project for design and development. Nothing that's been proffered by the city attorney or their alleged expert in the area rebuts the extensive information that we've provided that for every category under the definition of development and design, you as a city have the ability to review the project. What's not before you? I think this is important to mention. This notion of the RPZ, that was not the basis for the denial of the original building permit. The denial for the building permit was because the city attorney claims that the MAP Act applies. As you know, we disagree. The issue around FAA funding, obviously, respectfully, an important issue for you to consider. However, that is not the basis of why the building permits were denied, and that's not an issue before you tonight. There was a notion of an expired development agreement, mitigation measures that no longer apply. All these are a subterfuge to the very basic issue as to whether the MAP Act applies. And we believe that we have the legal basis to argue and also the practice of the city for a number of years to support the interpretation that a lot split is not required. In fact, Mr. Ennis, in the transcript that we submitted in our report, specifically acknowledged that none of these issues that he mentioned in his 10-minute presentation are at issue before you today. And the reason that is important is because we have before you a critical procedural issue. No one else that has been, in terms of the documentation presented, has indicated that any city in California, you have almost 500 cities in the state of California, not one has ever, and the city attorney or his special counsel or the expert that they allege to have retained have demonstrated, given us a specific example, how this position that they're now asking you to apply has ever been applied in any other jurisdiction in the state of California. As I mentioned, design and improvement is a critical piece here. Does the city have the ability to review the project on the basis of design and improvement? And we presented substantial information that has, again, not been rebutted in the level of detail that we presented it to you, that would actually contradict our position on it. This notion that because the building code is a state statute, that you cannot exercise your independent discretion relative to this project is a complete fallacy for several reasons. Number one, you have incorporated the building code into your municipal code. That's how it works. You have the ability to incorporate those rules in the state. You also have the ability to modify those provisions that the building code includes. And in fact, you have done that. Why? Because those are your provisions, not the state's provisions. Moreover, our position has always been that the building code is just a starting point for the review authority that you have with regards to the project. There's a number of other provisions within the municipal code, and you'll see in a specific example with regards to the Burger King, where you actually use and exercise the power that you have subject to those provisions that are not within the building code. They're within with other portions of your municipal code. I mentioned the legal opinion. I don't need to go into any of that or give it any more credit other than to say it cites to cases that were in relation to maps that were adopted at the turn of the century. Cases that considered exemptions on the municipal, under the Subdivision Map Act that don't even apply in this case. Cases that considered the Subdivision Map Act that did not incorporate the very provision that we say is exercised today. Again, no specific information has been received or submitted to you, despite the voluminous information and documentation that would actually rebut on a specific basis the position we have today, which is, as we point out in our matrix, you have the ability to review this project pursuant to development and design. That's what triggers the exemption that we're presenting to you today that applies to our project. And let me talk in more practical terms. We were able, subject to the Public Records Act, request information from the Planning and Building Department that actually shows 4 specific projects that are in full operation in the city of Hawthorne, that were issued permits to build a number of commercial buildings, and subsequent to the development of those buildings, as is the case with ours, new buildings were authorized. In none of those instances was a lot line adjustment requested. And let me take a specific example of that. With regards to the Burger King, this is actually a great example. As you can see from the site plan here, the lot for where the Burger King is located is a commercial regional center like ours. There's a larger building. That building was permitted pursuant to the standard plan approval that you have. It's not a discretionary approval. The planning department reviewed it, as did building and safety, and they authorized the development of that. Subsequent to the construction of that building, they wanted to put an amenity like a restaurant. They applied, as you can see from the permits here, they applied for a new building within that shopping center. It was a standalone building. It had a drive-through. It was a restaurant. And with regard to that building, what we've noticed, and this is the critical piece, the linchpin, with regards to why the city attorney claims that the exemption does not apply. He said that the building department is not the only department that should be reviewing this. And we actually agree. In fact, the permit that you see that we presented in your presentation is evidence that the planning department was also able to review the project. It reviewed it in connection with setbacks, with landscaping, parking, all the critical aspects of how you as a city have the authority to review and authorize the development of these projects without the need of a lot split. Again, with the RPZ, again, this is a complete distraction. The notion that we're not allowed to build within the RPZ is rebutted by the examples that the city attorney presented to you. He shows you a map that has buildings within the RPZ. I'm more respectful of your intelligence and your level of knowledge of how the city works to be able to tell you that there's precedent for the fact that you are able to review and properly, intelligently authorize your staff to proceed with the development of these projects subject to their consideration. We have other examples in other cities where buildings have been built within the RPZ and the world did not fall apart. And FAA did not stop the funding. They didn't stop the funding when you guys authorized the development of buildings within the RPZ previously. They did not. Why? Because those buildings, like our building, received FAA approval. The FAA approval that we have received, as we mentioned in our previous hearing, is consistent with the law and it's also consistent with the easement agreement that applies to our property. And what about this easement agreement that's been referenced? And I'll conclude with that important piece. The easement agreement, the avigation easement rather, which is an easement agreement, it controls the development of property within the RPZ. What it says is it's not a blanket prohibition on development. It doesn't say you cannot build buildings within the RPZ. In fact, it gives you a path of approval and gives you options. You can go to the Airport Land Use Commission, you can go to the city for approval, or you can go to the FAA for clearance. And they muddy the issue by saying, well, the easement agreement, by the way, this issue of the easement agreement has always been before the documents before you. And it wasn't until Friday that the city attorney decided to bring this issue up. Why? Because they understand that they have a weakness in their case. They understand that they're leading you towards a path that is likely to result in significant liability to the city. I'm available to answer questions. Our request is very simple, that we get the opportunity to work with the city to get our building and grading permits issued, and that you deny and reverse the denial of the building permits by the building department. Not only on the basis of prior precedent, through the wisdom of this city council and your staff, but also on the strong basis of state, local, and common law. Thank you very much.
Through the chair, I have a couple of questions.
Yes.
I have a question for you, sir. What is your name, sir?
Alfred Fryo.
Mr. Fragel. So when you say you had approval from the FAA, are you referring to the letter that was issued January 29, 2014?
Yes.
All right. And in that letter, which was called the Determination of No Hazard to Air Navigation, isn't there an advisory recommendation?
Council member, would you like to read that to me to refresh the language there? I'm happy to respond to
Yes.
it.
Doesn't the advisory recommendation say that it informs the sponsor of the inadvisability of building a structure within the RPZ which will result in the congregation of people within the RPZ?
This is a January 29th letter that we have. And are you referring to page 2 or page 1? Oh, that's the last paragraph. Sure. The issue there is actually historic in that the planning document by the airport has issued non-binding guidance to the city that you be mindful of structures within the RPZ. And the reason for that is it's important generally to have the certification that the FAA has issued, number one, and number two, for purposes of long-term planning for your airport, that you have the ability to expand that and therefore restrict and even acquire some of the parcels that are adjacent to the airport. In this case, as we know, while that is guidance, what the city has considered is, with regards to the locations of those buildings, what is the best aspect, what is sort of the best approach to it? What the FAA has said in that regard is, so long as you don't have or impede the path of the airplanes, their determination was that there's no hazard to the operation of the airport. And I think that's important because we are talking about, Councilwoman, as you mentioned, a restaurant. A restaurant is not, this is not the only restaurant use that's been authorized. As you know, you have a Target within the RPZ that's actually, the height of which is much larger than the one we have today. The amenities that are concentrated in that area, in addition to the parking structure, have the similar elements of it. The point being is, with regards to what the city decided to do, we are in compliance with that. You decided not to prohibit development in that area, but rather record this avigation easement. And so long as we demonstrate compliance with that avigation easement, you can proceed with your development. I would clarify just because I think it's an important point that you mentioned. Because there's this question about whether the FAA has the ability to grant approvals for local projects. That's actually the argument that the city attorney would have you believe in relation to how the easement, the agreement is enforced. With regards to that, both the airport has acknowledged, as does the FAA, that local land use approvals are the purview of you as a city, as is mandated by the state of California's constitution. The local rules with regards to the approval of developments cannot be issued by the FAA. They can be issued by the airport. They can only be issued by the city. And you have adopted a general plan that actually allows for the development of restaurants in this property.
Thank you. Mr. Ennis, would you care to respond, please?
Thank you very much, Councilmember Valentine. If I might, I want to respond, if I could, to one of the statements he made on that no city has ever applied this. There's 500 cities in California, none, I think is what he said, has ever applied this exception in the manner that we're suggesting. I'm city attorney of 3 cities. I would never advise my city to do other than what I'm advising Hawthorne to do. Number 2, there are 3 other colleagues of mine in my firm that represent cities, and they also have advised and taught on the MAP Act. They agree with my interpretation. The Santa Monica City Attorney's Office agrees with our interpretation. The expert that we hired agrees with our interpretation. I think it's fair to say that most cities, if faced with this particular issue, would interpret it in a manner consistent with the manner in which we have been interpreting it. But more importantly, Hawthorne has already interpreted the Subdivision Map Act in exactly the manner in which we're suggesting, back in 1989. In the Public Records Act request that Mr. Frejo made, it turned up an example of a lot split for purposes of lease of what ends up being a fast food restaurant. So I just wanted to make sure that was clear. On this easement issue, I think it's important to remember that history about the Exchange Project, the fact that you approved an EIR, you approved a specific development plan that encompassed and envisioned only development on the southern part of this lot and not the northern part. And I think that influenced how that abrogation easement was structured in this context specifically, how this property specifically was subject to a more constraining abrogation easement than maybe the case down at LAX, maybe the case on some other properties. I think, therefore, we have to look at the exact words, and we didn't really come to appreciate that until we got that letter from the FAA on April 28th, where they made it very clear in their letter, and that's attached to my staff report as Exhibit E, where they said that, we did not approve this project when we issued that letter of no hazard determination. That's not an approval by the FAA. And when we read that, we realized, in their abrogation easement, it says that they can't build a structure on this part of the property unless they have an approval from the FAA, which we realized they didn't, approval from the Airport Land Use Commission, which they haven't obtained, or it's consistent with the airport layout plan, which we don't believe it is. So I think that you have a pretty strong basis to at least have that issue further vetted when this goes through your planning commission process. Anyway, I hope that answers a portion of your question. Happy to answer any others.
Mr. Ennis?
Yes.
Through
Through the chair. Yes, sir.
The Prime Star, the company that's looking to see if we could go ahead and prove this, they're referring to certain lot splits that were avoided for the Rosecrans project.
Yes.
And possibly the project on El Segundo.
Mm-hmm.
Who was the planning director at that time, sir?
When we looked at the record on that, it looks like Mike Goodson was your planning director at the time.
Okay, yeah.
And I know that I think at that time, and maybe you want to find out about this, you had a very slim planning staff, meaning there weren't a lot of people. It might have been a time when something like this could have slipped through the cracks. But again, I want to point out what was interesting when we look into that record is to find that 1989 action where they in fact did require a lot split for a separate building.
Yeah, he's no longer with the city. He was recently terminated, so, okay, thank you.
Yes.
To the chair. Okay, so earlier you made reference that Ray Shun
Mhm.
is not the one, right?
He's your building official, but he's not your planner.
And that McLean is.
Correct.
Okay, so my question is, why Ray? Why wasn't it McLean?
And that's the point. We feel it should, meaning a building, they applied for a building permit and a grading permit. That goes to your building official. And your building official, on the advice of your city attorney's office and our office, we advised them saying, until there's a lot split, no building permit should be issued. And that's what he decided. If and when it's determined that this requires a lot split, it will go before Greg. It will go before his department and will be processed through your planning commission. So they will be brought into that process at that point.
And I'm reading your PowerPoint, page 8, where there's quotes and comment from our planning director.
That's actually from Mr. Frejo's PowerPoint, I think it was.
Oh, sorry about that.
And that's
Yeah.
correct. I believe these are correct quotes from Mr. McLean, who at your last public hearing on April 14th did kind of agree that he thought that some of these prior actions might have been done at a time where they didn't require a lot split. That was, I think, it was his strong suspicion that it might not have gone through those procedures back then. Well, it's, in looking at the record, we can't find, other than that one example in 1989 where those kind of things did go through the lot split approval process.
Okay.
Certainly in the Jamgochi and Burger King example, it appears there is no evidence of a lot split. But we don't feel you're bound, just because you did it in that one instance, you're bound to repeat that same approach. You have a right to look at the code, the law, the facts, and apply it as we feel the law requires.
Can I inquire with our city manager and possibly Mr. McLean? Can you provide, in short, what is the process for a project such as this? What is on the books today?
I defer to planning director.
Thank you.
Putting aside the issue that's before you, this is consistent with the zoning and with the general plan, and as the attorney had indicated, a restaurant would be permitted by right, meaning that a building permit would be the proper procedure.
That's it?
Yeah, I mean, aside from the question of the subdivision map app, which you're hearing.
Okay, so they could ultimately just build it and bring a restaurant, and that's it, pretty
Yeah.
much.
Yes. It's a fact that the zoning is C1, and it's a fact that that complies with the general plan, which is freeway commercial mixed use. And in those zones, we encourage restaurants, yeah.
Okay, so there was a lot of paperwork and information I did earlier today when I received it. I was trying to read through it. There's policy or legislation. Are you familiar with the legislation?
I haven't seen that document that you're looking at, so I don't know what you're referring to.
Okay, well, maybe I'll ask one of our other council.
Happy to answer any questions.
Okay, so there's made reference of legislation, policy that was drafted some time ago. It's in one.
Sure.
Can you explain that a little bit?
Absolutely, because this exemption is new in the sense that there is plenty of legislative history around it. It was designed to cover this exact scenario. There was a city in Northern California that had a shopping center where the shopping center owner and developer wanted to build a standalone building. And this exemption was not in the books at the time in the act, the Subdivision Map Act. And so he lobbied the legislature, presented the scenario that it would be an extraordinarily cumbersome process for everyone that wanted to build a standalone restaurant, like the ones that have been built previously in Hawthorne, to have to go through a lengthy subdivision process. In the case that they didn't want to sell the property. And so the legislature adopted the exemption specifically for these kinds of scenarios. And that was important for us to mention because, as I mentioned, no other city has done this, notwithstanding the recommendations of the city attorney. And I question if he's so certain about it, why he would have to get another law firm to write the legal opinion on his behalf. But nonetheless, with regards to the project that he has cited to, that apparently demonstrates that there was a lot split done. Let me point to that project specifically so I can at least give you the full picture here, because that seems to be the missing question. You heard from the planning director that is likely the most experienced person in this room with regards to how this is done in the city of Hawthorne, and he has confirmed what we've been telling you. But the case that's been referenced, and it's in one of the pages there that has the four images. The project that he's referring to is this site here. It's sort of a kind of oddly shaped site. The supposed condition that he claims is applicable to our project is this standalone restaurant here. This piece of the commercial center was subject to a lot split. And the reason for that is that it was requested by the tenant. It wasn't required by the Subdivision Map Act to be done. Why do we know this? Because there's other standalone buildings in this very center that actually are not subject to the Map Act. You can see that very clearly. It's an aerial of multiple structures within a single lot. And so no matter how we stretch reality or we stretch the law, we find that, as you heard from the planning director, and you've heard from us in terms of the issue before you, it's actually quite simple.
Can I direct my next question to Mr. Ennis, right?
Yes.
You made mention earlier that if we allowed this, that we're ultimately providing, maybe not providing the Planning Commission an opportunity to approve these types of projects and ultimately would not be needed to go through the Planning Commission whatsoever.
That's right. Because under your current zoning ordinance, you do not have these kind of restaurants subject to a CUP or design review. And so if you find the exception, meaning that the building code is sufficient to review this, then you don't need to go through a lot split, then the Planning Commission would not see this. So again, we conclude that this is subject to a lot split and should go before your Planning Commission.
I want to go back a few years. I've been here 28 years. And I've been very active in the community and was probably even before I even became a council member. But I remember the development over at 120th and Crenshaw. And I remember the FAA writing a letter ultimately to the city and basically saying, making some recommendations basically. And if I remember correctly, they weren't highly considerable of the projects along that zone there at Van Ness, 120th, Crenshaw in that